How to win in the Arizona small claims court, coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. This is Jordan Farkas. Very grateful to have you. And thank you to all those who have subscribed since my last video. I'm very appreciative. If you have not yet subscribed, don't forget to hit that subscribe button and the notification bell so you don't miss a future video. That will also help me to continue to produce videos like these to help you win in small claims court, which is my goal. If you wanted to learn a bit more about me, if this is your first time arriving at my channel, you can check out my bio video on the homepage of my YouTube channel. So without further ado, let's jump into today's topic, which is how to win in the Arizona small claims court. Now, if you're not residing in Arizona, don't worry. It's still worthwhile to watch this video. Of course, I've got many other videos that are offering general information and hacks and tips of winning in small claims court generally, but this is part of my series on specific small claims courts around the world, and I started with the US. My last video in this series was on the Alaska small claims court, and therefore I'm just going to continue pretty much in alphabetical order. The reason I didn't start with Alabama, as I mentioned in my last video, is because all the websites to that small claims court, that particular small claims court, were down. Maybe they're back up. I have to go back and check that, come to think of it. But in any case, today I'm doing it on the Arizona small claims court. And there's a whole host of information available online, which is amazing. And just like I was able to educate myself by going onto these various sites, which I'm going to link to in my description below, you can definitely do the same and just check out the links that I have in my description. Now, I was saying before that even if you don't have an Arizona, even if you're not based in Arizona, I should say, there's still a lot to learn just by understanding how the procedure works. And also, as part of these videos, I not only go through the procedure specifically to Arizona, but I also offer all sorts of tips and hacks about small claims court generally. So you can definitely benefit even if you're not in Arizona, but obviously, if you are based in Arizona, you will find this video much more on point. So let's jump in. For those who have seen my previous videos, you will know that I'm doing old school whiteboard. I'm thinking of switching to that idea where I'm kind of a small box in the corner, then I share my screen and maybe do PowerPoint, but I find PowerPoint to be a bit boring, whereas the whiteboard, it is old school and it does get caught up in the glare of the camera sometimes. But I do find that it's a bit easier for people to pay attention to me speaking with a whiteboard as opposed to me kind of into a little corner. But let me know what you think about that. You can leave that in the feedback. Again, I don't profess to be an expert videographer, and this channel is relatively in its infancy. I'm recording this in February 2025. So hopefully my skills will continue to improve, I should say. But in any case, my goal right now is focusing on content and substance and providing you with good ways of achieving success in small claims court. So Arizona small claims court, I have in green some general pointers about it, and then in red is more about the procedure surrounding the court. So let's start with the green. So number one to know is that as of the date of this recording, I always have to give that caveat because things can change, but as of the date of this recording, the limit, the monetary limit for suing in small claims court is $3,500. So if you have a claim that's less than $3,500 or up to $3,500, then you can sue in the Arizona small claims court. Now, of course, it's worth mentioning, as I've mentioned in previous videos, you do have an option of waiving any excess amounts to keep something within small claims court. So let's say you have a claim for $4,000. You may say to yourself, well, I can go to a higher court to sue there. And actually, I wrote this down. The name of the higher court is called the Justice Court in the Arizona small claims court. So if you have, let's say, a $4,000 claim, you can bring this to the Justice Court, because the Justice Court in Arizona hears claims between $3,500 and $10,000. But then you've got to think about, well, what about the fact that I may need to get a lawyer in order to bring that claim there? That may eat into what I can actually hope to recover in small claims court, because legal fees could be several $1,000s, for example, if not more. So you really have to make that consideration. On the other hand, it's not always advisable to rush to waive the excess amount. Sometimes strategically, you're better off suing in the higher court, because if you are going to leverage a settlement when you start in higher court, you may get yourself a higher settlement. Whereas if your starting point for negotiating is $3,500, which is what the Arizona small claims court offers you, then your settlement may be that much lower. So you always kind of have to do these considerations, these calculations. Is it worth going to a higher court, or is it worth keeping something in the small claims court. And what I mentioned, what I wrote down here as well, just so you know, claims between $10,000 and or from $10,000 and higher are in the superior court. That's just a little bit of extra information. Now, it's worth noting that in small claims court, the matter is heard by what's known as a hearing officer, or it's heard by a justice of the peace. Okay, so in Ontario, Canada, where I'm from, originally anyways, the small claims court judge is known as a deputy judge. But in Arizona, there's all sorts of different titles, as I've talked about before: justice of the peace, a hearing officer, whatever the case is. So when I say judge, just know that I'm kind of using the term loosely, but in various courts around the world, such as Arizona, there are different names for the person who's actually trying your case, the one who's actually going to be making the decision in your trial. Now, with respect to I mentioned attorneys earlier. In fact, in Arizona small claims court, attorneys are allowed, but it has to be by the mutual agreement of both parties, which is pretty interesting. So you can't have a case, based on what I read, where one party is represented by a lawyer and the other one isn't. It both has to be by mutual agreement. That's another example, by the way. In Arizona, if you really feel that you must have a lawyer with you, then you can ask, or you can decide to file your claim in the justice court, in the higher court, because you want to have that attorney. And in the justice court, you don't need the consent of the other party in order to have an attorney. But again, you have all the other considerations I talked about before. But just know that in small claims court, the only way you can have an attorney is if both sides agree. That doesn't preclude you, though, by the way, from consulting with an attorney before you go to court. So sometimes you may feel like you can handle the case on your own. And in fact, a big part of my practice when I was practicing as a small claims lawyer in Ontario, Canada, was to offer consultations to people whereby they don't have a lawyer in court, but they can certainly consult beforehand to make sure they have a good understanding of their evidence. Okay, so that's something that is available. In the future, I intend on offering not advice. I want to be clear, because I'm not licensed in jurisdictions around the world, but just sort of general information. If somebody wants to get a sense of, their evidence or questions they have, and they want to do that by consulting with somebody such as myself who has that experience, I do intend on offering that in the near future. But right now, as I said, my focus is on just providing the best content I can, and that will continue to be my focus, of course. But now that's my exclusive focus, I should say, so that you can win in small claims court. But there are ways of, even where lawyers are not allowed in court, there are ways of having the ability to consult with lawyers out of court. Again, of course, you have to take into account how much your claim is worth and what the fee is going to be. If a lawyer is charging, let's say, $500 for a consultation and your whole claim is for $400, then that doesn't make much sense. Although I did note down here that you can ask for reimbursement of costs and expenses in small claims court, but usually that's limited to the filing fee and various costs associated with having to provide a copy of the documents to the defendant, known as serving the defendant with your documents. But things like lawyer consultations in most small claims courts, I shouldn't say most, but the courts that I'm familiar with, they're not generally going to allow those sort of fees, because it is a people's court, and the fact that you chose to get that extra help doesn't mean that the other party should foot that bill necessarily. Of course, every case depends on its own facts, but still, sometimes it's worth consulting, because if you don't consult, you may find that you lose your case completely. So definitely it's a function of what your tolerance level is for risk, how much you want to inform yourself, and how much your claim is actually worth. Sometimes you may not be sure what it's worth, and that's another reason why you may want to have a consultation with an attorney. Okay. Now, something else I noted down is I've talked about jurisdiction before, knowing where to file your claim. And in Arizona, the general rule is that it is held, the claim is filed where the defendant resides. But there are various exceptions, okay? So there's the Arizona legislator, section 22-202, that has all sorts of exclusions for not necessarily filing where the defendant resides. That an example may be if you don't know where the defendant is located, for example, or another, if there's a spouse in a different jurisdiction, you can go to that. I'll try to remember to link to that in the description. You can go there to see where you should be filing your claim. But the general fallback that you should know is that you should be filing the claim where the defendant resides. Okay. Now, Also worth noting is that the small claims court is limited in the types of claims that you can file there. So for example, if you have a case for libel or slander, okay, that's under the guise of defamation, you feel that somebody defamed you, that's not something that can be brought in the Arizona Small Claims Court. Similarly, if you're asking for an injunction, what does an injunction mean? You want the court to make an order that somebody should cease and desist from doing something. Let's say somebody's, being a peeping Tom or spying on you or doing all sorts of, terrible things. The small claims court is not a venue where you can ask for that sort of injunctive relief. And similarly, the corollary of that is what's known as specific performance. So let's say you had a contract with somebody to have a real estate deal and the person reneged. There are remedies known as specific performance where you ask the court to say that you want to make this person honor the contract that they signed. But in small claims court, that remedy of specific performance is not available. And there's other examples. You would have to go to the government website to see those again, which I will have linked. But just bear in mind that not necessarily can you bring every single type of claim to small claims court. And that applies to small claims courts around the world. There's all sorts of limitations on what a small claims court hearing can consist of. And one of those reasons is because the judges are not necessarily as experienced in making decisions in those types of cases as they are for small claims. Small claims court is more of a people's court. It's a little less onerous. It's a little more loose, if you will. And therefore, the types of cases you're going to bring have to be more along the lines of, basic unpaid invoice, breach of contract, monetary damages, things of that nature. Okay, something else to bear in mind, by the way, is that I noticed that in the Arizona Small Claims Court, the general rules of evidence do not apply. Again, that's something that's common in all sorts of small claims courts around the world, because again, it is a people's court. So therefore, the court is not going to expect you, especially if you don't have an attorney, to follow all the nitty gritty types of rules of evidence that would otherwise apply in a higher court. And that's another consideration if you do want to be self-represented. But in a higher court in Arizona, you don't have to get a lawyer, but you may be obligated to follow the rules of evidence very closely. And if the other side, especially if they're represented by a lawyer, do know all those rules, they can really get you caught up in the weeds over there. So that's another thing to bear in mind. And so that takes care of some sort of general pointers, general tips to know about the Arizona Small Claims Court. Now we'll get a little bit more into the substance of the matter by talking about the forms. So what are the forms that you start your small claims court with? You start it with what's known as the summons, okay, where the person who you're suing must be summoned to come to small claims court to face the music, so to speak. The complaint, okay, which sets out how much money you're owed, why you're owed the money, et cetera, and then notice to P&D, that's the notice to the plaintiff and defendant. You have to have 3 copies of each of those forms, and you can prepare them and you file them with the Arizona Small Claims Court, and you have to make sure to provide copies of all these forms to the person you're suing, to the defendant. Again, this video is from the perspective of a plaintiff. Of course, in the future, my intention is to also do videos from a defendant's perspective, but the vast majority of people coming to this channel, at least by the data I have at this point, are mostly plaintiffs who are looking to sue and recover money that's owed to them. Again, if you are a defendant watching this, you could benefit by understanding how the plaintiff is looking at things, or how somebody like me is talking about how a plaintiff should look at things, and you can glean from this how you may want to approach things as a defendant. But again, I do understand that the perspective is as a plaintiff. So if you are a defendant, feel free to ask questions in the comments below, and I will try and address your questions from a defendant's perspective in a future video. But in any case, those are the 3 forms. Oh, I wanted to mention as well, before I forget, that there's a fantastic spreadsheet on the government website that I will try to remember to link to you as well. So it's a bit small to see, but you can see here, not a spreadsheet, it's a flow chart. I don't know if you can see that, but it's got a whole flow chart of how things work, how the matter starts. The plaintiff decides that they have a claim. The plaintiff tries to settle. The plaintiff settles out of court, or if they don't settle, then the plaintiff files a complaint. How much time period must elapse between filing and service of the claim, et cetera, et cetera. There's all sorts of different components that are brought out in this flow chart, and I think it's excellent. And anybody who has an Arizona Small Claims Court case should definitely have a look at that flow chart. I believe that's linked in the same section as all the forms are linked to in the Arizona Small Claims Court government website. So look out for that. Look out for the flow chart that's a part of the different forms that the government website offers. In any case, now I've mentioned before this idea of proof of service. So you have 45 days from when you serve the defendant with all the forms that you have to serve the defendant with. You have 45 days to file a proof that you actually served the defendant. Now, how do you serve the defendant? You can hand deliver something. You can do it by certain types of post. You can do it with what's known as a process server, as I mentioned in the past. But the point is that you can't just serve the defendant and expect that everything's fine. You have to file proof with the court that you actually served the defendant properly. Okay. Now, in the event that the defendant does not file a defense, we talked about this in the last video, it's known as default. Okay, so if the defendant does not file what's known as the answer, you have the defendant, I should say, has 20 days to file that defense, that answer to your claim. Then if you don't have that, then you can go and proceed to ask the court to note the defendant in default and get a default judgment. Again, the terminology may vary. You could go onto the website to see what that's actually called. Actually, I can look at the flow chart. Right now, it's actually called the plaintiff filing a request and affidavit for entry of default judgment, like I said. So that's in the event that the defendant does not respond within the time that the defendant has. Of course, if the defendant does respond, then within about 60 days, the court will schedule a trial. Whereas obviously that's where the plaintiff goes through the evidence that the plaintiff has and the defendant goes through the evidence that the defendant has. And then the decision maker, like I mentioned before, known as the justice of the peace or the hearing officer, makes a decision. Oftentimes it's on the spot, but they do have 10 days to make a decision from the date of the hearing. So not a long period of time you have to wait to get your decision, but just know you won't necessarily get the decision that day, but in most cases, you should be getting the decision that day. Now, just before I continue more on trials, I wanted to mention, I talked about in the last video, something known as a motion, okay? A motion is kind of like an intermediate proceeding where you ask the judge for certain relief. So there's only two types of motions in the Arizona Small Claims Court. Again, I jotted it down here. It's a bit small to read. One is a change of venue. So let's say a defendant is served in a certain jurisdiction. The defendant says, hey, I live completely different area of Arizona. Then the defendant can file a motion to change the venue. And also the defendant can also say, hey, I want to, or the plaintiff too, but usually it will be the defendant because the plaintiff started the action. I want to have this matter heard in a higher court. I want this heard in the justice court. And why would the defendant say that? Because maybe the defendant has a counterclaim that's worth more than $3,500, and the defendant may say, all right, I want to bring this, if the plaintiff is going to sue me, I'm going to sue the plaintiff back, and therefore I'm going to bring this to a higher court. Also, because I want a lawyer, the defendant can say. So the defendant can make a motion to stay the proceedings in the Small Claims Court of Arizona and bring it to the higher court so that the defendant's full counterclaim can be heard in the jurisdiction where it belongs. Okay, of course, the defendant doesn't have to do that. The defendant also can make a counterclaim and waive anything above $3,500 to keep it in Small Claims Court, which the defendant may do strategically as well. Again, each case depends on its facts, but that's the point, is to know that that motion does exist. And the other type of motion I jotted down here is a motion to vacate judgment. So I talked about the idea where if the defendant fails to file a defense within the 20 days, the plaintiff could go ahead and ask for default judgment. But let's say what happens if you have a case where the defendant did not get notice, or something happened, the defendant got sick and they couldn't file their defense on time. So the defendant can make a motion to reopen and vacate a judgment that the plaintiff may have gotten against them. Now, the defendant has to be careful because there's all sorts of enforcement procedures, like I've talked about in past videos, I'm going to talk about here, where when the plaintiff gets judgment, the plaintiff could start garnishing and doing a writ of execution. So if the defendant's not careful, let's say the defendant sits on something for a year, the plaintiff may have already started enforcement. They may have already garnished the defendant's bank account. So if you are a defendant watching this, and there has been judgment entered against you, or you know you were served and you never did anything about it, you shouldn't take that lightly. You should act immediately. And if you're a plaintiff, conversely, and strategically, if the defendant has not filed on time, then you can go ahead and move quickly to try and ask for judgment and move to enforcement. Now, the one thing to bear in mind that I remember as a lawyer practicing that used to be a big source of frustration is that we would move quickly for our client plaintiffs to try and get that default judgment and get the enforcement and try and collect on the judgment. And then we would go through all these hoops and all these steps and all this money and all this time, only at the last second for the defendant to go ahead and wipe that clean by bringing this motion to vacate the judgment. And at least in Ontario, I can't speak for Arizona, but it's probably similar. More times than not, the judge will give the defendant the benefit of the doubt and allow the defendant to have their day in court. Of course, a good attorney, or even if you're not an attorney, you're watching this now, you can get a tip from me. We'll ask for certain terms. They'll say to the judge, okay, you want to reopen this? That's fine. But Your Honor, we want to know that the defendant must put, a deposit of $3,500 into court to satisfy judgment as a condition for having this case reopen. Now, I don't know if such a thing exists in Arizona small claims court. In Ontario, there was an accountant of the Superior Court of Justice where you can make settlements like that. Of course, you can have one party, you can have an independent attorney act as a trustee to hold that money pending a decision. So there's all sorts of types of strategic considerations you can make. But that's a bit beyond the scope of the average small claims court case. And certainly if you're not an attorney, these types of negotiations may be a bit high level. But in any case, just know that we used to have all sorts of frustrations that had to do with going through hoops to get judgment and collect on judgment for small claims court, only for it to be vacated at the last minute. And I say that because you may want to consider actually even giving another notice to the defendant to say, hey, we served you with these papers and you haven't filed your response, your answer, your defense. Please go ahead and do that, or else we are going to continue with default. And you're not doing that because you care so much about the defendant. You're doing that because you don't want to go through all these hoops only for it to be turned aside and vacated at the last moment. So that's something to bear in mind as well. Now, back to trial. I mentioned before the idea of having a trial within 60 days. I've talked about the idea of adjournment in last videos. In Arizona, it's called a continuance. And that means by no later than 15 days before trial. Let's say a trial was scheduled for a date that you cannot attend. So you can do this in writing. You can ask the judge for a continuance to reschedule the trial. And I mentioned the decision being within 10 days of the trial being heard. Of course, I saw it on the Arizona court website. There is a subpoena form that you can provide. Remember, that's when you want to secure witnesses. The same consideration. If you have to subpoena them, they may not be the most friendly witnesses, but sometimes it does make sense to have that subpoena to make sure that you've secured your witnesses. And you can tell the judge if the witness doesn't show up, you did what you had to do by law so that you don't prejudice your case. Okay, but always remember, you want to have your witnesses, you want to have all your evidence ready. Even if the rules of evidence are more relaxed, you can never be too prepared. And I've gotten through a lot of that in my earlier videos. And finally, I talked about enforcement. Again, the mechanisms are with a constable. There's garnishment. So an example would be garnishing the bank account where the defendant banks, or there's garnishment of wages. There's probably rules in place about how much of wages you can take. Look into that on your own. That's beyond the scope of this video, but just know there is an enforcement mechanism of collecting on judgment known as garnishment, and also writ of execution, as I talked about. There can be a writ of execution in general, where you ask the constable to find any sort of personal property belonging to the defendant, such as a car. For example, if the defendant owns a car, you can ask for that to be repossessed, and there's all sorts of information about how that's done. I think I forgot the name of the court. There's a certain court within Arizona that I found that has all sorts of information about that enforcement, and I will do my best to remember to link to that in the description below. And then there's writ of execution that has to do with property, also known as a lien on property, and that can be very effective, as I've talked about in last videos, to ensure that the defendant cannot sell their property without effectively paying off your lien first. So there are enforcement mechanisms in place in the Arizona Small Claims Court, as there are probably in every other small claims court around the world. Okay, so I hope that that concludes this video on the Arizona Small Claims Court. I hope you found this video to be helpful. If you are watching this from Arizona and you've had experience in small claims court, or even if you haven't, but know a thing or two about the Arizona Small Claims Court specifically, I'd love to get your feedback. What do you think of this video? Do you find it helpful? Is there anything that I forgot that you think I should add? Again, I'm limited and there's only so much I can add in one video. My videos are pretty long as it is, but definitely I'm open to your feedback if you feel there's something else that could have helped you. Of course, if you know anybody in the Arizona Small Claims Court or having a small claims court case in general, you can pay this forward by forwarding this video to them. Once again, for those who have subscribed, thank you so much. I really appreciate it. And for those who have not yet subscribed, don't forget to hit that subscribe button. It takes a second, and the notification bell so you don't miss a future video. So that concludes this video. And until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.